everyone to the final round of Hippard Open. We have a great round in store for you, and we hope that everyone enjoys the show. Counsel, whenever you're ready to proceed with the court, you may begin.
Yes, Your Honor. Spencer Packard, Packard. I'm here with my co-counsel Brooke Bentley, Bentley. We're here on behalf of the United States of Lone Star, and we're ready to proceed to opening statements pursuant to a few housekeeping matters and one motion in limine.
Okay. And our defense?
Brett Hargis for the defense, Your Honor. It's Hargis.
Okay. Is that counsel? Is that all appearances? Or are we missing a person?
I'm here as well, Your Honor, on behalf of the defense, Casey Borthwick, Borthwick.
Okay, and Mr. Packard, you said you had a few housekeeping matters?
Yes, Your Honor. First, may we assume that the defendant has been arraigned?
Yes, you may.
May we also assume that the witnesses have been pre-sworn?
Yes, you may.
Now, may we, when we object, in the event that there is a battle for the audio through the Zoom platform, may we raise our hand to give a visual cue of our objection?
Yes, that would be helpful. Thank you.
And lastly, may we also invoke the rule, Your Honor?
Yes, consider the rule invoked.
Now, as far as our witnesses go, we do have an expert witness. May they stay in the courtroom?
Yes.
Okay, that concludes our housekeeping.
All right. Did Mr. Hargis and Ms. Borthwick have any housekeeping matters they would like to address?
One housekeeping matter, Your Honor. We would ask that the jury be read the charge before closing statements.
Okay. Any objection, prosecution?
No objection, Your Honor.
Okay.
Thank you, Your Honor.
Okay. And I believe, Mr. Packard, you had a motion, you said?
That is correct. One motion in limine. Now, as you know, Your Honor, this case is about insider trading, where the defendant, Jordan Belfort, gave inside information to a D. Azoff, and where D. Azoff traded on that information. We anticipate that the opposing counsel may want to try to argue that D. Azoff knew that Belfort would have been upset if Azoff was to trade on the inside information. As you know, Your Honor, that's speculation. Azoff cannot speak to Belfort's state of mind, and it's on those grounds that we object.
I think that can just be addressed within the normal course of business. I think that's just an issue of speculation, which would be apparent from the testimony that is either presented or not presented. So let's just let the testimony go forward and we'll kind of deal with it as it comes up.
Yes, to clarify, Your Honor, can we be assured that it won't come up during opening statements?
I think that's a fair assumption.
All right, thank you. That's all that we have for motions in limine. We're ready to proceed to opening.
All right, Mr. Hargis, did you or Ms. Borthwick have any motions that you wanted to present?
We have one motion in limine we'd like to present, Your Honor.
Okay, what is that?
There is an interview with a Mrs. Shannon White, who is, per local rules, each side are only allowed to have two witnesses. Ms. White is not one of those witnesses, and we ask that any mention of that interview be excluded as hearsay. We won't be implying that the prosecution is trying to hide a witness. We just ask that there be no mention of it.
I think that would be dependent somewhat on what the purpose of the reference to the interview is. What do you have to say, Mr. Packard or Ms. Bentley?
Absolutely, yes. I agree with what you just said. The purpose that we are going to mention this interview for, it's testimony about the reputation of Jordan Belfort. And as you know, I mean, the objection is on the grounds of hearsay. But under Rule 803.21, reputation concerning character, statements to those effect are exempted from the rule of hearsay.
Well, I think we might have to address those on a case-by-case basis rather than as a blanket rule. So let's be careful as we're approaching that testimony so that any objections can be heard before the testimony is blurted out, but we'll just deal with them on a case-by-case basis.
Yes, Your Honor.
Thank you, Your Honor. We have no more motions at this time.
Okay, well then, unless either side has anything else to present to the court, I think we're ready to get underway. All right, you may begin.
Your Honor, may we assume the jury is present?
Yes, you may.
Two friends, a secret plan, and easy money. Ladies and gentlemen of the jury, my name is Spencer Packard. I have my co-counsel here with me, Miss Brooke Bentley. We proudly represent the United States of Lone Star. This case is a case about insider trading. Whenever someone commits insider trading, they get rich, but it's not by the sweat of their brow. It's only on account of who they happen to be friends with and the fact that their friends are willing to cut corners for them. What we intend to prove to you today is that the defendant, Jordan Belfort, gave D. Azoff inside information, that D. Azoff traded on that inside information and got rich. We further intend to prove to you that Jordan Belfort expected something in return for divulging this information when D. Azoff would trade on that information. Now we'll present evidence and witnesses to tell you a little bit about who Jordan Belfort is. And what you'll come to find is that Jordan Belfort lives the kind of life that we get to see in the movies only. Jordan Belfort, you'll hear, grew up as a very privileged child wanting for nothing. His dad is the owner of 3 separate businesses, 2 of them Audi dealerships. You'll hear that Jordan Belfort grew up to become a multimillionaire and that now he's the CEO of his very own large company, Look Mono Hands. And I'm going to talk a bit about Look Mono Hands. I'll call them LM&H. Our witnesses and the evidence are also going to tell you about D. Azoff. And you'll come to find that D. Azoff is not that different from Jordan Belfort. When D. Azoff grew up, she inherited her family's large insurance firm. During college, she would spend her time racing her family's fleet of Porsches. Now, these 2 individuals, Jordan Belfort and Miss Azoff, you'll come to find that they were very, very close friends. They would spend their time at each other's fancy vacation homes. They would host each other there. They would ski together, go on fancy exotic car shows together. They would travel together, and they would spend time at each other's country clubs. Now, specifically, you're going to see and hear evidence about the favors that D. Azoff would do for Jordan Belfort. Specifically, you'll hear that D. Azoff would lend his private jet to Jordan Belfort, that D. Azoff would let Jordan Belfort stay at her cabin, and that D. Azoff lent significant capital to Jordan Belfort whenever Jordan Belfort was starting up his companies. Now, you'll learn also about Jordan Belfort's company, LM&H. What you'll hear is that LM&H, during November of 2019, it wasn't doing very well. It was hemorrhaging for cash. But you'll hear that Jordan Belfort not only was able to keep his company afloat, he was able to shoot its stock's value into the stratosphere because Jordan Belfort landed a whale of an investor, Elon Musketeer. Now, specifically, what you're going to hear is that Elon Musketeer proposed to purchase over 1/3 of LM&H. Now, whenever Jordan Belfort got this information that Elon Musketeer was interested in Jordan's company, Jordan was elated, ecstatic. And the first thing that he did was call his best friend, D. Azoff, to tell her about it. Now, you'll hear that whenever Azoff got that information, she turned around and traded on it, getting rich. What you're also going to hear is that D. Azoff is a very talkative person. You'll hear that as soon as D. Azoff got that information, she told her stockbroker, she told her family, she told her friends. And what the evidence is going to show too, our witness, Special Agent Pat Denham, they're going to tell you how everybody in Belfort's inner circle knew about this Musketeer deal before the public did. Our expert witness, Ms. Powell, is going to tell you how important this information was. That knowing about this Musketeer deal, this major acquisition, it's something that most stockholders would want to know about whenever they're placing their bets in the stock market. Now, I want you to ask yourselves, members of the jury, throughout the course of this trial, ask yourselves, why would Belfort give that information to Azoff? I want you to listen for the evidence to show the favors that Azoff would do for Belfort. And I want you to ask, how important would it be for Belfort to preserve that relationship, to maintain those perks, those connections with D. Azoff? Now, I'll say this, our case, insider trading, it's unique. It's a very unique crime. You're not going to see any guns here, no weapons, no blood, bruises, or physical pains. But there are victims. The victims are the corporations that are defrauded, whose reputations are tarnished. The victims are the shareholders that are kept outside of the loop, and the participants of our economy who are forced to ask the question of whether the system is rigged against them. That's why we punish insider traders, ladies and gentlemen. Now, our burden to prove to you is that Jordan Belfort is guilty beyond a reasonable doubt. Now, what that means, it doesn't mean that you have to be convinced of our case the same way that you're convinced that the sky is blue or that fire is hot. It means that you have to, by the end of this trial, be able to knock out the serious doubts, the reasonable ones. If the defendants come up here and they tell you any argument, any hypothetical situation that you don't believe to be reasonable, that does not have to change your verdict. Now, it's our submission to you that we're confident that we will be able to meet our burden. We bear that burden proudly. We're confident that by the end of this trial, you'll find Jordan Belfort guilty beyond a reasonable doubt, that you'll find the only thing that the evidence can suggest and that justice demands. That is that Jordan Belfort is guilty. Thank you.
Thank you, Mr. Packard. Mr. Hargis, will you be presenting the opening?
Ms. Borthwick will be presenting, Your Honor.
Thank you. Please proceed, Ms. Borthwick.
Thank you, Your Honor. May it please the court. Good afternoon, everyone. My name is Casey Borthwick, and my co-counsel is Brett Hargis, and we'll be representing the defendant, Jordan Belfort. Ladies and gentlemen of the jury, you are here today because Jordan Belfort has been wrongfully accused of insider trading for his business, Look Ma No Hands. Now, this case is about three things: friendship, greed, and betrayal. Friendship in the fact that D. Azoff and the defendant, Mr. Belfort, were best friends for over 10 years. They traveled together, they shared a passion for car shows together, and their children were even best friends. Now, this case is also about greed in the fact that Miss Azoff was rich and she was wealthier than Mr. Belfort. And she wanted to maintain this considerable wealth. So she traded off confidential information in Belfort's company, Look Ma No Hands, to gain millions in the company. She just couldn't resist such an opportunity. And this case is also about betrayal in the fact that when Miss Azoff traded off this information, she breached the trust of Mr. Belfort and their friendship and ruined the reputation of his company, a company he worked his lifetime to build and to reach success. Now, Jordan Belfort is the founder of Look Ma No Hands, which is a self-driving auto technology company that was the product of Belfort's love for cars and his talent in mechanical engineering. Belfort never gave up on the future success of his company, and he worked as hard as he could, and Musketeer's interest in this company is a result of all of his hard work. Now, today you're going to hear from several witnesses, and you must listen very closely and remember that the prosecution must prove to you beyond all reasonable doubt that the defendant, Jordan Belfort, willfully, knowingly, and with an intent to defraud, traded secret information in hopes to gain a personal benefit for himself. Members of the jury, if there is even a hint of reasonable doubt, you must acquit Mr. Belfort. In our criminal justice system, defendants like Mr. Belfort are innocent until proven guilty and not guilty until proven innocent. Now, you're going to hear from several witnesses, and the prosecution's expert witnesses are going to paint a picture that the prosecution wants them to. Agent Denham is the one who brought this case to the state, and she is going to tell you that all about Mrs. Azoff's trading activity, and she's not going to tell you anything about Mr. Belfort's intent to defraud his company. You're also going to hear from Jordan Belfort himself, and he's going to explain to you that he was simply just excited to tell his best friend about this big news in his company. You ask why that he would tell anyone about this? He told his best friend. Who wouldn't want to tell their best friend about this awesome opportunity? You're also going to hear from D. Azoff, who subsequently broke Belfort's trust and Belfort's devastation when he found out about this betrayal. And Belfort's also going to explain to you that he knew the law on insider trading. Now, the prosecution will tell you that Belfort provided this information to gain a personal benefit for himself, However, Belfort had nothing to gain by Miss Azoff trading on this confidential information. In fact, Mr. Belfort had everything to lose, and the only person who sought a personal benefit was Miss Azoff. Members of the jury, I ask that you follow what the court will instruct you on here today and the evidence that we're about to show you, and remember that the prosecution, and not myself, not my co-counsel, nor my client, Mr. Belfort, must prove to you beyond all reasonable doubt that Mr. Belfort is guilty of insider trading. Thank you.
Thank you.
Your Honor, before we proceed to any presentation of evidence, I have a motion for a mistrial. There was a statement about the burden of proof here specifically that if you find even a hint of a reasonable doubt, you must acquit. Your Honor, this is a misstatement of the law and we want a mistrial.
That motion will be denied.
Yes, Your Honor.
Are we ready to proceed?
Yes, Your Honor. The prosecution calls Agent Pat Denham to the stand. Hi, Ms. Denham. May I
Hi.
proceed, Your Honor?
Yes, you may proceed.
Please introduce yourself to the jury.
My name is Pat Denham.
And what do you do for a living, Ms. Denham?
I am a special agent with the Lone Star Securities and Exchanges Commission.
How were you involved in this case with Jordan Belfort?
I was the lead investigator on the investigation into Jordan Belfort and Look Ma No Hands, otherwise known as LM&H. This is Jordan Belfort's company, to determine whether he had committed securities fraud in relation to his deal with Elon Musketeer in December of 2019.
Okay, so we'll talk about your investigation in some more detail in a minute, but first, just tell us a little bit about who Jordan Belfort is.
He is the chairman and the CEO of LM&H, a tech company that has recently been involved in the self-driving cars industry. And he's also the defendant in this case today.
And is Mr. Belfort in the courtroom today?
Yes.
Can you identify him based on his hair and a piece of clothing for the record?
Yes. He is wearing a blue shirt and he has brown hair.
Let the record reflect that the defendant has been identified.
It will so reflect.
Now, let's talk about your investigation in some more detail, Agent Denham. What was your first step?
Well, first, we always do routine investigations into trading patterns when there's been a significant event in the stock market. And basically, we are just looking for any evidence that someone purchased a bunch of stock before a big deal went public. In this case, specifically, we were monitoring a $684 million investment in LM&H by Elon Musketeer.
What did you find when you looked into those trading patterns?
Well, we noticed a dramatic spike in the number of shares that were purchased by Ms. Azoff during the month of December.
What exactly was significant about the month of December?
Well, Musketeer's investment in LM&H was announced on December 31st of 2019. So we looked into the weeks preceding that deal.
And how exactly did you see these spikes?
I subpoenaed the trading records of Ms. Azoff, or D. Azoff, sorry.
Your Honor, permission to share my screen constructively with just the witness opposing counsel and the court for purposes of offering an exhibit?
Granted.
Agent Denham, can you see Exhibit 1 on your screen?
Yes, I can.
Okay, I'm showing you what has been previously marked as Exhibit 1. Without getting into its contents, do you recognize this document?
Yes.
And what is it?
It is a summary chart of Ms. Azoff's trading activity during November and December of 2019 that I prepared in the course of my investigation.
And is this a true and correct copy of that summary that you prepared?
Yes, ma'am.
Your Honor, at this time, the prosecution offers Exhibit 1 into evidence and tenders to opposing counsel.
Any objection?
No, Your Honor.
All right, that'll be admitted as Exhibit 1.
Permission to publish Exhibit 1 to the jury, Your Honor.
Granted.
Agent Denham, explain to us what you thought was suspicious in this trading activity.
Okay, well, first you can see that there was very little activity in November. He only made one purchase, and that was on November the 6th. Around this time, LM&H stock was really declining, so this lack of activity does correspond with that. But then his purchases dramatically increased during December. You can see he made several purchases starting on the day that Mr. Belfort gave him the information about the Musketeer deal on December the 3rd.
And just to clarify, Agent Denham, when you have been saying his, did you mean Miss Azoff?
Yes. Sorry about that.
No worries. So when you saw this activity in November and December of 2019, did this seem consistent with insider trading behavior in your experience?
Yes.
And did this insider trading occur in the Lone Star stock market?
Yes, ma'am.
Let the record reflect that venue has been established.
It will so reflect.
So Agent Denham, how did you follow up on investigating what Miss Azoff knew after you saw this?
So we started by subpoenaing records. Through this, we obtained evidence that on December 3rd, when Belfort first learned of Musketeer's interest, he called Miss Azoff and told her about it, excuse me. And that corresponds with Miss Azoff's purchases on December 3rd. And then we also obtained a recording of a phone call between Miss Azoff and her stockbroker, Stephen Lopez, that took place on December the 10th. In that in that phone call, excuse me, Miss Azoff told him about Musketeer's interest and told him that she wanted to purchase shares in LMNH because of that deal with Musketeer.
Did Miss Azoff say in this phone call how she knew that information?
Yes, she stated that Miss Belfort, or Mr. Belfort, excuse me, had told her about it.
Agent Denham, what else did you need to determine that Mr. Belfort had committed securities fraud in your investigation?
Well, Belfort had to anticipate receiving some type of benefit in return or in exchange for that information. And Belfort must have had some expectation that Miss Azoff would actually trade on that information.
Okay, so let's talk about that benefit that you first mentioned. Did you find evidence that Mr. Belfort anticipated a benefit from Miss Azoff?
Yes. Based on our investigation, we believe that Belfort was sharing this information with the expectation that it would strengthen their friendship and their business relationship as well. And, and it would ensure that Miss Azoff would be maintained as a significant investor in the future.
Did you find any evidence of any tangible benefits?
Yes, we did. Did someone say something?
No, you
okay.
Go.
Sorry. Miss Azoff actually frequently treated Belfort to fancy vacations, dinners, golfs, and plane rides on her private jet. So in addition to the fact that this would solidify their friendship and their business relationship, continued access to those perks would also be a great benefit to Mr. Belfort that he would have been anticipating.
Now, you also mentioned expectation as an element. Did you find any evidence that Mr. Belfort expected Miss Azoff to trade on this info?
Yes, Mr. Belfort discussed it in a December email to Miss Azoff that we came across during the course of our investigation.
Permission to share my screen, Your Honor, constructively again with just the witness opposing counsel in the court for purposes of offering an exhibit.
Granted.
Agent Denham, can you see Exhibit 12 on your screen?
Yes.
I'm showing you what's been previously marked as Exhibit 12. Without getting into its contents, do you recognize this document?
Yes.
And what is it?
This is the email between Mr. Belfort and Miss Azoff that I was just discussing.
And is this a true and correct copy of that email?
Yes.
Your Honor, at this time, the prosecution offers Exhibit 12 into evidence and tenders to opposing counsel.
Any objection?
This is hearsay, Your Honor.
May I respond, Your Honor?
Yes, please.
This is a statement by the defendant, Jordan Belfort, and therefore this is an admission by a party opponent, and therefore it is not hearsay.
Objection is overruled. And Exhibit 12 is admitted.
Yes, Your Honor. Permission to publish to the jury.
Granted.
So, Agent Denham, how does this email show that Mr. Belfort expected Miss Azoff to trade on the information he gave her?
Well, the key phrase here is at the end when he says, and I'm about to make it up in a big way. Because this email was sent on December 14th, we believe that that's in reference to the deal with Mr. Musketeer and how it was going to improve LMNH's stock prices and thus Miss Azoff's profits. This email indicated to us that, Mr. Belfort was essentially aware of Miss Azoff's additional trades in December.
Now, besides this email, was there any other evidence that Mr. Belfort expected Miss Azoff to trade on the information?
Well, the cornerstone of it is really their relationship. Even prior to Mr. Musketeer entering the picture, Ms. Azoff was continuing to buy more and more Element H stock and repeatedly ignored the fact that the company was on the brink of bankruptcy, actually. And from this, we know that Azoff could be a bit of a risk taker and a bit impulsive with trading. And, you know, Mr. Belfort certainly would have known this given how close they were. And so we believe, based on that, that Mr. Belfort would have been aware of Ms. Azoff taking the chance and trading on that information.
Did you learn in the course of your investigation whether Mr. Belfort had told anyone else about the deal?
Yes, to my knowledge, he also mentioned it to others besides Azoff and his friend group.
So, Agent Denham, what did you ultimately conclude in your investigation?
We ultimately concluded that Mr. Belfort had committed securities fraud.
No further questions, Your Honor. Pass the witness.
Okay. Cross-examination?
Yes, Your Honor. Hi, Ms. Denham. How are you today?
Good, how are you?
Good, thank you. So let's start off. So you said you looked into Ms. Azoff's trading patterns. Is that correct? Because they were suspicious?
Yes.
And did you ever look into Mr. Belfort's information on
No,
his trading activity?
No.
And there was no suspicious activity in Mr. Belfort's portfolio. Is that correct?
Objection, Your Honor. The witness just testified that she never looked at Mr. Belfort's trading activity, and therefore it would be speculative to ask her what was in it.
Response?
I'll ask a different question, Your Honor.
Okay, please rephrase.
Ms. Denham, you didn't look into any of Mr. Belfort's trading activity, is that correct?
Yes, because I wouldn't expect for the owner of the company to so obviously out himself. That's not really what we've seen or what I've seen in the course of my 5 years being in the SEC. So.
Okay, and you also stated that in your summary chart, there was a dramatic departure from Ms. Azoff's prior activity to November 6th. However, you failed to include this information in the summary chart. Is that correct?
Which information?
The prior trading activity to November 6th.
Yes, I did not include the information prior to November the 6th because per SEC guidelines and procedures, we are only looking at a few weeks before the big deal was announced. And that is why I did not include anything before November.
And in regards to the relationship between Mr. Belfort and Ms. Azoff, you would agree that they frequently, even before Musketeer's interests, visited these country clubs, stayed at each other's homes. They've been friends for 10 years.
I'm not sure. I only know what I looked at in the course of my own investigation. So I can't really speak to what happened in the past or, before I entered the entire scenario. So I would say I don't have an answer for that.
Okay, and let's talk about this email. You said that you believed the last sentence of the email specifically, you know I'm about to make it up in a big way. You believe that this was in reference to the Musketeer investment. However, did you ever try to rule out anything else as to why he would have said this?
Yes, we actually did look into different inferential kind of possibilities. But ultimately, we did conclude based on the other circumstantial evidence that we had that Mr. Belfort was in fact committing securities fraud with Ms. Azoff.
Ms. Denham, isn't it possible that Mr. Belfort could just have been referring to another vacation, another golfing trip in reference to this email?
Yeah, and that would be receiving a benefit for the information that he exchanged to Ms. Azoff. So.
No, he would be doing another trip with Mr. Azoff.
Right. And so if, in that case, in the course of my investigation, I would still conclude that a trip might be something that Mr. Belfort was anticipating in that email.
But you didn't rule this out and you just concluded it was the Musketeer announcement. Is that correct?
Well, even if they were talking about just going on a trip, me and my team of investigators would still conclude that that was probably an anticipated benefit that Mr. Belfort would be receiving in exchange for the information that he gave, the insider trading information.
Would you agree that there's some doubt as to what he meant by this, Ms. Denham?
No, I wouldn't.
So you believe 100% it was about Musketeer's announcement?
Based on my 5 years in the SEC following procedures and guidelines, yes, I do believe that.
Thank you, Your Honor. I have no further questions.
Okay. Does the prosecution have further questions on redirect?
No, Your Honor. May this witness step down?
Yes.
Your Honor, at this time, the prosecution calls Ms. Powell to the stand.
Okay, you may proceed when ready.
Yes, Ms. Powell, thank you for joining us. Why don't we start having you introducing yourself to the judge and jury?
Yes, of course. Good afternoon. I'm Michael Wesley Powell.
Ms. Powell, can you tell us in 1 or 2 sentences, what's your connection to this case?
Sure. I was called by the Lone Star Attorney's Office to offer my opinion on the impact of Elon Musketeer's investment into Jordan Belfort's company, Lukmano Hands.
All right, I'll ask you more about your opinion in depth in a moment, but let's get to know you first. Can you tell us what you do for work?
Sure. Currently, I'm the vice president of Lone Star River Associates. We are an international financial advising firm, advising clients both in private industry, government, and academia.
Did you go to college before starting with Lone Star River Associates?
Yes, I received both a bachelor's in business and then later an MBA.
After getting your degrees, your bachelor's and your MBA, did you proceed to receive any certifications, that have anything to do with finances or fraud?
Yes, I'm a chartered financial analyst and I'm also a certified fraud examiner.
Ms. Powell, are you also a member of any professional associations?
I am. Both the Business Valuation Association and the Chartered Financial Analysts Association of Chicago.
Now, would you say that these experiences, your education, and those memberships gave you a specialized knowledge in business, economics, and securities fraud?
Yes, I would.
Do you also believe that your knowledge, skill, education, training, and experience would be helpful for the jury understanding the facts of this case?
Yes, I do.
Your Honor, at this time, we tender Ms. Powell as an expert in business, economics, and securities fraud.
Any response?
Your Honor, the defense requests permission to question this witness en voir dire.
You may.
Thank you. Good afternoon, Ms. Powell.
Good afternoon.
Ms. Powell, have you ever worked for a state or federal agency that investigates financial crimes?
My company advises some government agencies.
But other than advising, you haven't?
I'm sorry, could you repeat the question, the original question?
Yes, ma'am. Have you ever worked for a state or federal agency that investigates financial crimes?
I've only advised government agencies who do that type of work. So I've worked with them tangentially, but not specifically as an employee.
Thank you, Ms. Powell. Have you ever testified for the defense in a trial involving financial crimes?
I've been called to testify on a number of matters. That very may well be one over my long career.
Are you being paid by the prosecution to testify, Ms. Powell?
Yes, I am. My usual rate for testimony is $695. That's comparable to my rate as a vice president and executive of an international corporation.
That's a lot of money, Ms. Powell. How can we trust you to give a fair and neutral opinion?
Objection, Your
Sure.
Honor.
Well,
Objection, Your Honor, to the sidebar comment by the attorney.
Sustained. Can you rephrase, please?
I'll withdraw the question, Your Honor. Ms. Powell, are you always paid by the state to testify?
I'm paid whenever I'm called to testify as an expert witness, whether the state is my client or any other company or industry.
And are the methods stated in your report the only methods you used to investigate this case?
I relied upon methods that are relied upon in my field by experts, yes.
And you consider this a thorough investigation?
Yes, I do.
Okay. Your Honor, the defense is not satisfied that this expert is qualified under Rule 702. And we object to her being tendered as an expert witness.
Any response, prosecution?
Yes, Your Honor. If anything, I think this void dire had established that this is indeed a qualified expert to speak on matters having to do with securities fraud. We've established that she has knowledge, she has education, experience, training, and skills, and that's what's necessary to lay the foundation for an expert. She is qualified to be an expert, Your Honor.
The objection is overruled.
Thank you, Your Honor.
All right, Your Honor, may we assume that the jury is in presence now?
Yes.
Okay. Ms. Powell, my understanding is that you arrived at an opinion in this case. Can you tell us what kinds of materials you reviewed in arriving at your opinion?
Sure. Well, in addition to simply my general knowledge about business, I relied on statements from Lukman Hands, news articles, NASDAQ and Chartered Financial Institute, and SEC reports.
Are these materials that you just mentioned the same types of materials that are typically relied on by other experts in your field?
Yes, absolutely.
And is your opinion here today the product of reliable principles and methods?
Yes.
Did you apply those principles and methods to the facts of this case?
Yes, I did.
Do you also hold your opinion out to a reasonable degree of scientific certainty?
Absolutely.
Now, Ms. Powell, what is that opinion?
So in this case specifically, my opinion is that knowledge of Elon Musketeer's interest in investing in Lukman Hands was material, non-public information.
Well, let's break that down for a second. Can you tell us what it means for information to be non-public?
Sure. It simply means what it sounds like, that it's information that people generally don't know about.
Now, what does it mean for information to be material in this context?
Sure. So that has a fairly specific meaning. It's information that, if it were to become publicly known, would likely affect either the market price of a company's securities or a person's decision to purchase, sell, or hold stocks in a certain company's securities. So anything that would impact the market.
Well, Ms. Powell, would you be able to give us any examples of what material non-public information would look like?
Sure. I think the two most obvious for for lay people is quarterly earnings or sales that might differ significantly from what the public consensus would be. And then second, just a major purchase or sale on the horizon.
Is it also your belief, Ms. Powell, that either of those two examples became a reality in this case?
Yes, both of those.
Do you think that creating a demonstrative or a timeline would help the jury understand how these became a reality?
Yes, I do.
Your Honor, permission to share screen so that we can create a demonstrative?
Granted.
Can you see my screen, counsel?
Yes, I can. Can I verify that the judge and jury can see it as well?
All I'm seeing is a blank screen.
Oh, yes, Your Honor. That's all that we have shared right now.
Okay.
Okay, well, Ms. Powell, let's go ahead and talk about the major acquisition example that you just gave us. Would you mind drawing a horizontal line across this screen to represent a timeline?
Yes.
Now, what was the first event that took place that's relevant to your opinion that there was a major acquisition here?
Sure. So the first event of note would have happened about 6 to 8 weeks prior to the announcement of Musketeer's interest in LMNH, and that developed 6 to 8 weeks would have been about November 15th.
Okay, well, let's go ahead and label at the bottom that this is whenever Elon Musketeer developed an interest in LMNH. And to back up for a second, can you tell us who Elon Musketeer is?
Yes. Elon Musketeer is a billionaire. He's an investor specifically in these types of companies. He has one himself.
Okay, and who is LMNH?
LMNH is Jordan Belfort's company. It stands for Lukman Hands. It's a self-driving car company. And really prior to Musketeer's investment, it was sort of a small tech company, so to speak.
Well, can you tell us, when did the public find out that Elon Musketeer was interested in LMNH?
Sure. So that announcement did not occur until December 31st. So let me mark that.
Okay. Why don't we label that Musketeer's announcement? That's perfect.
Yes.
Now, could you represent on this screen as well, what period of time would it be that someone, if they knew about this information about Musketeer's interest, when would that be considered material, non-public information?
Any time period between Musketeer developing an interest and when that information became public information. If that information were to get out and be available for individuals to act in the marketplace upon, that's material non-public information, all of that time period.
Now, is it your opinion also that Jordan Belfort had possession of this information at any point in this time?
Yes.
When would that be?
So that would have been on or before December 3rd.
Okay. Now,
And that is when, oh, I'm sorry, go ahead.
No, you go ahead, Ms. Powell. My apologies.
Well, that's when Belfort began negotiating with Musketeer.
Now, did you also, in arriving at your conclusion in this case, did you find anything out about D. Azoff?
Yes, I did. So on December 12th is when D. Azoff made the first purchase based on this material non-public information.
On when was that?
On December 3rd. That's when Azoff bought the first groupings of LMNH stock based on this information.
Okay. Well, what eventually happened to LMNH's stock value after the public's announcement?
It skyrocketed. It jumped 23%. This was the largest investment in LMNH history.
And do you believe that Azoff made money from his trades on this information?
Yes, I do. He made a significant amount of money.
Well, Your Honor, at this time, we ask that this demonstrative be preserved as the prosecution's demonstrative A.
All right, it will be done.
All right, and I have no further questions for this witness. May this witness, I pass them for cross-examination.
Yes. Cross-examination, when you are ready, you may proceed.
Thank you, Your Honor. Ms. Powell, directing your attention to December 17th, 2019, did you learn of a board of directors meeting of LMNH that took place?
Yes.
And isn't it true that a consensus was reached that this investment by Musketeer would benefit the shareholders of LMNH?
Yes, that's correct. They definitely saw it as something that was going to benefit the stock.
Isn't it also true that Mr. Belfort was the one pushing this narrative so the shareholders would be benefited?
Yes, I believe that Belfort was aware that the purchase would positively impact the stock price of LMNH.
Thank you. Ms. Powell, did you find any evidence of Mr. Belfort personally trading on this alleged non-public information?
No, I was looking into what the impact of his exposure of that information would have been, not his personal trading.
Thank you, Ms. Powell. And did you find any evidence that Belfort financially benefited from Ms. Azoff's trades?
Not directly. I found information that Azoff benefited greatly. And then there was also discussion.
Ms. Powell, did you find any?
Yes.
Did you find any information?
Objection, Your Honor.
Okay.
Yes, I believe the witness was responding to the question and was interrupted. Can the witness finish the question?
Yes, finish your answer, please, ma'am.
Yes. Well, part of what I looked into was the scope of Belfort and Azoff's relationship. And so they were very, very close at this time. They spent a lot of time together. They traveled together. They shared interest in property and other assets. So there was an element of the benefit that Belfort stood to gain from Azoff's significant earnings through this information that she shared.
Ms. Powell, isn't it true that you found no evidence that Mr. Belfort had a bad purpose in disclosing this information to Ms. Azoff? Yes or no, please.
I'm sorry, I can't speculate as to Belfort's state of mind.
Okay. Isn't it also true that you found no intent to defraud LMNH by Mr. Belfort? Yes or no, please.
Objection. This calls for speculation.
I'm going to overrule that. You may answer the question.
Yes. Yes, I believe there was circumstance. Yes, I believe there was circumstantial evidence communicating that Belfort did have the capacity and the intent to benefit.
No further questions, Your Honor.
Okay. Is there any redirect?
No redirect, Your Honor. May this witness step down?
Yes, you may. Thank you.
Your Honor, this concludes the prosecution's presentation of the evidence. The prosecution rests.
Thank you. Does the defense have witnesses?
Your Honor, if we could present a motion outside the presence of the jury.
You may.
Thank you, Your Honor. Pursuant to Rule 29 of the Federal Criminal Rules of Criminal Procedure, at this time, we'd move for a judgment of acquittal based on insufficient evidence to sustain a conviction. Specifically, we believe that the prosecution has failed to prove the element of the intent to defraud LMNH, and that they have failed to prove that Mr. Belfort acted willfully when he disclosed this information.
Prosecution, I'm sorry?
Yeah, I was asking if I could respond, Your Honor.
Yes, I was trying to get you to. Please do.
Your Honor, the prosecution has presented ample evidence for a reasonable jury to find beyond a reasonable doubt that Jordan Belfort did commit this crime. Specifically, we have provided evidence that Jordan Belfort shared material non-public information between December 3rd and December 31st when he shared that information about the deal with Mr. Musketeer becoming a major investor with D. Azoff before it went public. Miss Denham and Miss Powell both testified to that. We also provided evidence that Mr. Belfort would have expected that Azoff would trade on that information when we saw Exhibit 14 with Agent Denham, where it mentions, how Mr. Belfort would make it up to him. And finally, we provided evidence that Mr. Belfort anticipated a benefit when Agent Denham discussed his expectation of this continued business relationship and continued perks of Azoff's, like the vacation homes, the country clubs, the private jet. Specifically what counsel mentioned, the intent and the knowingly and willfully aspects. We provided that evidence that the defendant shared this information with Azoff knowingly, in the sense that it was not an accident. He intended to share that information with Ms. Azoff. He shared it willfully or with a bad intent, because we have shown that he expected Ms. Azoff to trade on the information. And we know that he shared that with the intent to defraud the company of the confidentiality of that information when he told Ms. Azoff about the information in the first place. Thus, Your Honor, the prosecution has met its burden, and we request that the motion be denied.
The motion will be denied. The defense may proceed with its witnesses.
Thank you, Your Honor. The defense calls its first witness, Ms. D. Azoff. Good afternoon, Ms. Azoff. How are you doing?
Good.
Will you please state your name for the court?
D. Azoff?
Now, Ms. Azoff, do you currently have any pending felony cases?
Yes, I pled guilty to the charge of insider trading on September 25th, 2020, in connection with my purchase of securities based on my possession of material non-public information on Elon Musketeer's interest in trading in Look Mono Hands.
And Ms. Azoff, what is Look Mono Hands?
It is a self-driving car company who Jordan Belfort founded, of which, yes, he was the founder.
Did you ever invest in Look Mono Hands, Ms. Azoff?
Yes, I saw huge potential in LMNH, so I contributed to the startup capital, and once they went public, I bought shares of the company. And I have, Belfort was one of my good friends, so I had a lot of confidence that his endeavors would go well.
And Ms. Azoff, was there any consequences to your guilty plea to insider trading?
Yes. So before going to jail, I was a CEO of our family's insurance company, and I am no longer the CEO. And unfortunately, the company may not survive this scandal. I should never have traded on this information.
And Ms. Azoff, what was your relationship with Mr. Belfort like?
We were good friends for the past decade. We each had 3 girls that were of similar ages. We met at a car show, and we really hit it off, and our families travel together. We hang out. We're really close friends, or we were.
And Ms. Azoff, did you ever pay for Mr. Belfort on these activities?
Yeah, I would pay for him and he would pay for me. I would say it's split pretty evenly. If we played golf at his country club, he would pay. If we played golf at my country club, I would pay. It was just typical friendship. We weren't counting pennies or anything.
And Ms. Azoff, how did you learn of Musketeer's interest in LMNH?
Jordan called me really excited one day in, I think, early December, and told me that Elon Musketeer was considering donating a large amount of money and that he was going to Vegas to go to a super secret deal with Musketeer to hopefully finalize this. He was so excited. He was just calling me to share the good news. So that's how I found out.
And what did you do after you got off the phone with Mr. Belfort, Ms. Azoff?
I bought 1,750 options of LMNH.
And did you know that the information Mr. Belfort gave you was confidential or not?
Yes, I knew it was confidential, and I knew that I shouldn't have traded on the information and that I was betraying Jordan's trust by doing so, but I couldn't stop myself. It was too tempting, and I know he was probably going to be pretty mad about it.
Objection. Speaking to whether Belfort would be upset about this, that's speculation.
Sustained.
May I have, Your Honor, may I request that this be stricken from the record and the jury be instructed to disregard it?
The jury will be instructed to disregard that last piece of the testimony.
Ms. Azoff, did you share the Musketeer information with anyone else?
Yes, I shared it with my siblings and my stockbroker, Mr. Lopez, but not specifics.
Okay, Ms. Azoff, I want to show you what's been marked Exhibit 11. 1 second. Can you see that okay, Ms. Azoff?
Yes, I can.
Can you identify this for me?
Yes, this is the email that I sent my siblings. The subject's Christmas present. It essentially was me telling them that I had information that they would want to hear.
Your Honor, I would like to offer Exhibit 11 into evidence.
Any objection?
Your Honor, no, we do not object to the admission of this document.
All right, Exhibit 11 will be admitted.
And Ms. Azoff, to your knowledge, do you know if Mr. Belfort knew that you sent this email?
Objection. Objection, that is speculative.
I think she can answer
Your Honor,
whether she knows. That will be overruled.
May I proceed?
Yes, please answer the question.
I did not tell Jordan that I was sending this email. I just told my siblings, you know, what I thought would be a great investment opportunity. I severely regret betraying Jordan's trust like that.
Okay, and Ms. Azoff, did you and Mr. Belfort have a trust in one another and often shared confidential information?
Yes, having been such good friends for 10 years. Having been such good friends for 10 years, we had a level of trust and understanding between each other, and we would oftentimes tell each other about great things that are happening in our lives, bad things. We've both been divorced. We talked about that. We had a very great friendship and a lot of trust.
Objection. Narrative.
Let's keep it question and answer.
Ms. Azoff, Mr. Belfort had trust in you as your friend.
Yes.
Objection. Asking about Mr. Belfort's trust is speculation.
That's sustained.
Thank you, Ms. Azoff. I have no further questions. Pass the witness.
All right, you may proceed on cross.
Ms. Azoff, I want to say this up front and assure that I am not asking this question to be antagonistic. It's just that we are a little pressed for time. Can we agree that if I ask a yes or no question, can I get a yes or no as an answer?
If it's a question that can be answered with yes or no.
Absolutely. Well, let me start off with your relationship with Belfort. You and Belfort would do a whole lot of things together, right?
Yeah, we went skiing, we visited each other's houses, ate dinner together, golfed together.
You would, yeah, that's a yes.
Yes.
Okay, you would hang out at each other's vacation homes.
Yes.
Right. You would hang out at each other's country clubs.
Yes.
You would let Belfort fly on your private jet.
Sure.
And if you saw photographs of these homes, those country clubs, and that private jet, you would recognize it, wouldn't you?
Well, it depends on the picture, but probably.
Your Honor, permission to share screen constructively with this witness, opposing counsel in the court?
Granted.
Ms. Azoff, can you see what's been marked as prosecution's exhibits 3, 4, 5, 6, and 7?
Yes.
Without going into their contents, do you recognize those exhibits?
Yes.
And do these exhibits fairly and accurately reflect those vacation homes that we were talking about, those country clubs that we mentioned? And that
Objection, Your Honor. Relevance.
Response?
Yes, Your Honor, we're in the midst of laying a foundation for these documents. Further, this is proof of the benefit that Mr. Belfort received by giving this information to Azoff. It's relevant because it goes straight to an essential element of the case.
The objection is overruled.
Ms. Azoff, you recognize these?
Yes.
And they fairly and accurately depict those homes, those country clubs, and that airplane, right?
Yes.
Your Honor, at this time, the prosecution offers exhibit 3, 4, 5, 6, and 7 into evidence, and we tender to opposing counsel for objections.
Your Honor, these exhibits are unduly prejudicial to Mr. Belfort.
Brief response?
Sure.
Your Honor, it goes to an essential element of the case. The fact that it hurts our opposing counsel's case, that does not make it unfairly prejudicial.
The objection is overruled. The exhibits will be admitted.
Now, Your Honor, may we constructively publish these to the jury?
You may.
Okay, Ms. Azoff, this picture right here, exhibit 3, this is your vacation home in Deer Valley?
Yes.
You would let Belfort stay there once in a while, right?
Yeah, we took vacations to each other's houses, and he would stay at mine and I would stay at his, which I think is the next.
Yes.
Yes.
This is Mr. Belfort's vacation home in the Yellowstone Club, right?
Yes.
He would host you once in a while over at that home?
Yes.
This is one of the country clubs that you would spend time together at.
Yes.
This is another one of those country clubs, right?
Yeah, we were each members of a different country club, so we would golf at the other country club, pool days, dinner, all of the above.
Yes, Ms. Azoff, just a yes or no will be fine. This last one here is the jet that you would lend to Mr. Belfort, right?
Yes, that's my jet.
Okay, so it's fair to say that Mr. Belfort had quite a few perks in being your friend, right?
I would say that being friends with Jordan is a perk in itself.
Okay, I understand. Well, let me ask now about LMNH. You bought some stock in LMNH when it went public, right?
Yeah, I think I said I contributed to the starting capital. I bought stock when they went public. I trust my friend.
Ms. Azoff, just a yes or a no. Is that a yes to my question?
Yes.
Okay. Now, whenever there was an article that was published that talked about LMNH doing poorly, that concerned you, right?
I wouldn't say that it concerned me. I would say that it was concerning as, well, it's not even concerning. It's an article, so it brings up questions. So I was, as an investor, wanted other information before I made a decision.
Right. You were considering selling your shares after reading that article, right?
Selling all of my shares in LMNH?
Any of your shares in LMNH.
Sure, but anyone that owns stock sells and buys shares all the time.
I understand, but that's a yes to my question.
Was I considering selling some of my shares?
Yes.
Sure.
Okay. Well, you and Belfort spoke after this article was published, right?
Yes, we speak all the time. We did before I betrayed his trust.
After speaking with Belfort, you decided to not sell those shares, right?
Sure.
Okay. Now, what Belfort told you specifically was that the article was bogus and that LMNH would hit its quarterlies. That
Objection, Your Honor. These are out of court statements Mr. Packard is talking about.
Okay,
Happy to
Mr.
respond, Your Honor.
Yes, please do.
Yes, the declarant of these statements is Mr. Belfort. That's the defendant. And so it's not hearsay. It's a declarant by the opposing party.
Okay, that objection will be overruled. You may proceed.
Ms. Azoff, what Mr. Belfort told you specifically was that the article was bogus and that LMNH would hit its quarterlies that following Thursday, right?
I mean, I don't remember the exact conversations I'm having with him. I had 2 to 3, we spoke a lot.
Do you remember him telling you that LMNH would hit its quarterlies that following Thursday?
Sure.
Okay. Now that is information that the public wasn't privy to.
I didn't hear a question.
Was that information that the public was not privy to?
I guess. I don't know. I'm not aware of what the public was or was not privy to.
Now, once you heard that information, you emailed 2 of your friends and told them to not sell their shares in LMNH, right?
Jordan reassured me, so I reassured my friends.
Right. You told them that LMNH was going to hit its quarterlies.
Right, and that the article was bogus.
Okay. Well, let's go ahead and talk about your guilty plea now. You pled guilty to a charge of insider trading.
Yes.
Okay. You were indicted for that crime on June 28th of this year.
Sure. I don't remember the exact date, but that sounds about right.
Okay. And you pled guilty on September 25th.
Yes.
You knew that Musketeer wanting to buy stock in LMNH, you received that information before the public got it, right?
Yeah, my best friend called me and told me good news. And I, as a businesswoman, was tempted. And so I bought shares and I couldn't help myself. And I've regretted it every day since, which is why I turned myself in and guilty pled to the charges.
Yes, I understand, Ms. Azoff. This is something that you knew was wrong, right?
Right, which is why I turned myself in.
Right. You couldn't help it but to purchase those shares.
Right, because as a person in my position, I saw that it was too good to pass up, and I just purchased the shares, and I've regretted it every day since.
Right. It was, I want to ask a little bit more about secrets. It's true, Ms. Azoff, that you don't believe that you can keep a secret, right?
I have let it slip what people are getting for their birthday, but I don't know what you mean.
It's just a yes or no to my question. Do you believe that you have a hard time keeping secrets?
Sometimes.
Is that a yes?
Sometimes. I told you not all yes or no questions can be answered with yes or no.
Well, it is your belief that you're well known in your circle of friends for not being able to keep a secret, right?
You can't, I don't think it's fair to just put all secrets on the same level. There's the...
Ms. Azoff, I apologize. I'm trying to phrase my question as just a yes or no, as we discussed previously. It is your belief that in your circle of friends, you are well known for not being able to keep a secret. Yes or no?
Yes. When you put your hand up, is that because you want me to stop talking?
It is me to clarify my question.
Okay.
Now, I want to ask this too. Your trades, the ones that are in connection with the Musketeer interest in LMNH, you made those through your stockbroker in Windy City, right?
Yes, Mr. Lopez.
Yes, your stockbroker's name is Mr. Lopez?
Yes, Mr. Lopez at Trades R Us in Windy City.
Now, I want to clarify this right now. Yes or no, did you or did you not share the information that you received from Mr. Belfort with your stockbroker?
I said earlier that I did, but I didn't say specifics.
Right. Do you remember being interviewed before this case?
Yes.
Do you remember having a summary of that interview provided to you?
Yeah, I'm sure at some point.
Do you remember having a chance to review that statement?
I didn't do that today, but I've read it before, and I believe I say I didn't ever tell Mr. Lopez things.
The question is whether you had a chance to review that statement or not. You had a chance to review it, right?
Yes.
And you signed that document?
Right, after the interview, but the interview happened a while. It's not fresh on my mind.
Just the question is whether you signed it, Ms. Azoff. You did sign it, right?
Yeah, I think anyone that has it has a signature at the bottom that's mine.
So you adopted those statements as your own.
Sure.
Your Honor, permission to share screen with this witness in the court and opposing counsel?
Granted.
Ms. Azoff, this is that interview, isn't it?
The summary of it, yes.
This is your signature at the bottom here?
Yes.
Okay, and this is what says that you adopted those statements as your own.
Yes.
I want to read from the second to last page, just these sentences. Tell me if I read it correctly. All of Azoff's trades were executed by his broker who lives in Windy City. Azoff stated that Azoff never shared the information obtained from Belfort with the broker. Did I read that correctly, Ms. Azoff?
Yes, it messed up my pronoun, but other than that, yes.
Now, you'd agree with me, that's in direct conflict with what you just told us here under oath.
No.
You told us that you did share information with Mr. Lopez that you obtained from Mr. Belfort. And in that statement, you said that you never did. You disagree that those are in conflict?
I do, because I didn't share specific, I didn't tell him the specific number, and I didn't tell him who the investor was.
Your Honor, I have no further questions for this witness.
All right. Any redirect?
Yes, Your Honor, I have a few questions.
You may proceed.
Ms. Azoff, did Mr. Belfort know that you shared information with your friends about the Barron article?
Objection. The question was asking whether Mr. Belfort knew. That's speculation.
You can rephrase that.
Ms. Azoff, based on your knowledge, did Mr. Belfort know that you shared information with your friends about the Barron article?
I never told him, and I don't think any of my friends did either.
No further questions, Your Honor.
All right. You may proceed with your next witness, defense.
Thank you, Your Honor. The defense calls Jordan Belfort to the stand.
Good morning.
May I proceed, Your Honor?
Yes, you may.
Good afternoon, Mr. Belfort. Would you please introduce yourself to the jury?
Hello, my name is Jordan Belfort. I'm a businessman, entrepreneur, salesman, engineer. Yeah.
And are you married, Mr. Belfort?
I was once, but no longer.
Any kids?
I have three beautiful daughters.
What exactly do you do for a living, Mr. Belfort?
Honestly, I like to invent. I like to make people's lives better. That's my main goal. I like to come up with inventions that are new, that are great for everybody. Right now, I've kind of my baby project is this Look Ma No Hands company, which is self-driving vehicles.
Why self-driving cars, Mr. Belfort?
I became really interested in them in the early to mid 2000s. Always loved exotic cars, and I'm an engineer. It's what I do, and why not combine my two loves and make a product that makes the world better?
How's your company been doing?
It's been doing great. Thank you for asking.
That's good. Now, directing your attention to December 3rd, 2019, did you receive any news concerning your company?
I would say I received some of the best news of my life. Beyond the birth of my three daughters, I'd say it was probably the fourth best day of my life.
And what was that news you received, Mr. Belfort?
I received news that billionaire Elon Musketeer wished to invest in my company, possibly. He wanted to meet with me.
And who is Mr. Musketeer?
He's a billionaire that works on technology. He's an investor. He's very, very famous in my kind of work.
Okay. Now, how did this news make you feel?
It was, like I said, it was the best day of my life. I couldn't contain myself. I was jumping up and down. I was excited. It was incredible.
Now, were you supposed to get in contact somehow with Mr. Musketeer to gauge his interest?
Yes, a friend of a friend actually met with him and told me, hey, he wants to see you.
Objection, Your Honor. The witness is testifying about hearsay. A friend of a friend told me.
I couldn't quite tell where he was going with that. The witness is instructed not to recount out-of-court statements of others. But if you want to refer to actions of others, that's fine.
Yes, Your Honor.
Mr. Belfort, without recounting out-of-court statements, how were you supposed to get into contact with Mr. Musketeer?
I was to go to Las Vegas and meet with him.
Okay. And did you tell anyone else about this news?
Well, I first told my lawyer because he needed to accompany me there. And then I called my best friend in the world at the time, Azov. And I told him the great news. I tell him everything. He was my best friend at the time. And so I told him, I wanted someone to be excited with me.
And just to clarify, that's Miss D. Azov?
Yes, that is Miss D. Azov.
Thank you. Now, what is the nature of your relationship with Miss D. Azov?
I couldn't actually say we have a relationship anymore.
Why is that?
She betrayed my trust to the what I would consider the ultimate level. She used me as a pawn and try to gain her own wealth.
Okay, but before this betrayal, what was your relationship with Miss Azov?
She was my best friend. We traveled together. We did business together. Mostly we hung out while our 3 daughters played with each other. She also has 3 daughters and would have play dates. And yeah, we talked probably 2-3 times a week for the past 10 years.
Okay, and did the two of you ever discuss business?
A little bit. Like I said, like we were both very successful business people. And so from time to time, business would come up, of course.
Mr. Belfort, would you say there was some sort of expectation that these discussions would just be between the two of you?
These discussions I always considered to be a best friend type of relationship, the kind of confidentiality most people have between their best friends. So yes, I always assumed that everything we said was to be private.
Okay. Now, was Miss Azov an investor in the company, in your company, LMNH?
Yes, she was.
Did you ever discuss her stock or investments in your company?
No, we didn't.
Okay. Let's go back to this meeting in Las Vegas. Will you tell the jury kind of how that meeting went?
Yeah, so I arrived with my lawyer. Musketeer was there with a bunch of his guys, mostly engineers. He kind of sat back, listened to me speak. I tried to, give him my elevator pitch about why my company was one of the greatest in the world. Didn't really seem too impressed. Very quiet, said, hey, how would $1 billion do with your company? To which I was excited.
Objection, Your Honor. Hearsay as to the statements of Elon Musketeer.
Response?
I agree, Your Honor. Mr. Belfort, can you keep from recounting out-of-court statements, please?
Yes. So he got up, walked away without shaking my hand, and I spoke with his engineers.
Okay, thank you, Mr. Belfort. So how did you feel about the potential investment after this meeting?
I wasn't too excited about it, honestly. I felt like the meeting fell flat.
Okay, and when was the next time you heard anything about this potential investment?
About a week later, Musketeer's people sent an offer to buy some shares at a pretty low price. I wasn't very impressed, and the board and I ultimately made the executive's decision to deny the offer.
Okay, and what happened after that?
They rebounded with a much better offer, about $19 a share, and we were elated. We decided to accept the offer.
So there was a deal that was finally reached?
Yes, there was a deal that was reached.
Okay. Now, did you do any trading yourself during the time this deal was pending?
Of course not. It'd be illegal.
Why not?
It would be illegal. It'd be immoral. I knew I had non-public material information. I knew I was not to trade on that. This was my baby. I would never do anything to try to put my company in jeopardy.
Okay. Going back to Ms. Azoff, what kind of communications, if any, did you have, the two of you have, during the month of December of 2019?
Like I said, she was my best friend at the time, so it's hard to recount every type of communication we had, but I'm sure there was texts, phone calls, in person.
What, if anything, did you expect Ms. Azoff to do with this information?
I expected her to be excited for me. Like I said, I'm divorced. I don't really have anybody I can share this kind of information with. She's my best friend, so I was really hoping for someone to be excited for me, be happy for me, cheer me on.
Sure. To your knowledge, had Ms. Azoff ever used information you had given her in the past to benefit financially?
Absolutely not. Absolutely not.
So you trusted her to keep this information confidential. Is that fair to say?
Absolutely.
Okay. Mr. Belfort, how did you react to the news that Ms. Azoff had traded illegally off this information?
I was heartbroken. There's no other way to put it. I honestly couldn't believe that somebody that close to me would use me and put me in a situation that I'm here today. And I still can't believe that she would do that to me.
Have the two of you spoken since then?
No, absolutely not.
No. All right, just a few more questions, Mr. Belfort. Would you and Ms. Azoff spend time together in your free time?
Yes, before she did this to me, yes.
Sure. What would you do?
We both liked exotic cars. We'd do that. We would spend time, like I said, with our daughters. We'd go places. Their typical best friend relationship.
Who would normally pay for these things?
I like to think it was pretty close to 50-50, pay our own share. One of the bright sides of having a decent amount of money is that you don't have to keep track of every receipt.
Seems like you two were close. Were you ever worried that your friendship was in jeopardy?
Never.
Relevance.
I'll allow it.
Do I
What was the
answer?
answer?
I apologize.
Go ahead.
Never. I
Man.
never was afraid that our relationship was in jeopardy.
Okay, Mr. Belfort, there's been a lot of talk about this email. What did you mean when you said, "I'm going to make it up in a big way"?
I meant that I'd get the next one. Like we said, I was able to use the cabin. We used each other's places. We went to each other's country clubs. I meant that the next trip would be on me.
So it had nothing to do with Ms. Azoff profiting off the information you gave her?
Absolutely not.
Thank you, Mr. Belfort. I have no further questions.
All right. You may have cross-examination.
May I proceed, Your Honor?
Yes.
Now, Mr. Belfort, you and Azoff were best friends, right? Or Ms.
Were.
Azoff, excuse me. I'm sorry,
Correct.
could you repeat your question? I couldn't delay.
Sorry. We were best friends.
And Ms. Azoff has and had become a very successful and wealthy businesswoman, right?
Yes, she was good at business.
She took you to her vacation homes and country clubs, right?
Yeah, we went to each other's. We traveled
Right.
a lot together, hung out together.
She paid for your meals at upscale restaurants.
Not typically.
So it's your testimony today that you didn't often eat together and Ms. Azoff didn't often pay for you?
My testimony is that I paid my fair share in all of our friendship. And
But you would
leech
agree
off
with me that
Miss Azoff.
you would agree with me that Ms. Azoff in the past paid for your meals at upscale restaurants?
Yes, from time to time she would pick up the tab, and from time to time I would pick up the tab.
And she let you use her private jet, right?
Yes.
And if you two were no longer friends, safe to say you would have lost access to those things of hers, right?
Right, I'd get my own private jet.
Okay, but you would have lost access to her things specifically.
I'd be more concerned about losing her friendship like I did, but yes, you don't typically use your old friends' items.
Okay, and so like you just said, if you two were no longer friends, you would also lose a close friend and business partner, right?
I'd lose a close friend. I wouldn't expect to lose business off of friendship.
Okay. But Ms. Azoff was one of your earliest investors in LMNH, right?
Correct.
And by December 2018, she was fairly heavily invested.
We didn't typically discuss how much she was invested in my companies.
So it's your testimony today that you don't know how much she was invested in LMNH?
No, I don't know how many shares she held in my company.
Okay. But you would agree with me that before this deal with Mr. Musketeer, LMNH wasn't doing well, right?
No.
Is that a no, you do agree, or a no, it wasn't doing well?
I think we were doing quite well. I think I'm a very great business person. I think I would have dug us out of anywhere.
Okay, so you just said dug us out. Are you saying, like, isn't that you saying that you weren't in a good place with LMNH?
Depends on how you define a good place.
I'm simply asking you, Mr. Belford, you just said that you could have dug yourself out even without Mr. Musketeer. Isn't that you implying that LMNH was not in a good place before the deal with Mr. Musketeer?
I'm sorry if I misspoke, but I guess my statement may have been that if I were ever to be in a bad place, that I could get myself out of it.
Okay. You would agree with me that over the years, Miss Azoff was always a loyal investor, though, right?
Again, I knew she was invested in my companies, didn't know how much. She was a loyal friend until this, of course.
Right, but she was continually invested, right?
Correct.
And you cared about Miss Azoff, right?
Yes, I think most people care about their best friends.
And you wanted her to be successful?
I mean, I never wish bad upon her, that's for sure.
So you would have felt bad if she had been invested in your company and LMNH had gone under, right?
No.
You wouldn't, it's your testimony today that you wouldn't have felt bad at all.
No. I mean, she's a businesswoman. She understood the risk she was taking by investing in startup companies. Every person like me or like her knows that investing in a company, there's no personal feelings involved in that. It's business, strictly.
So I understand that you had a business relationship with her, and that's your opinion as her business partner, but as her friend, it's your testimony today that you wouldn't have felt bad at all if she had lost all of her money from being invested in LMNH and it went under.
Well, she never would have lost all of her money from one of my companies going under. I'm sure she had a diversified portfolio, and if not, that'd be her own fault.
But didn't you just testify that you don't even know how much she was invested in LMNH?
Correct. That's why I said I'm sure, not that I'm positive or not that I know.
Okay. But you did make a deal with Mr. Musketeer in December 2019, right?
Of course.
And this deal ultimately was very good for the company, right?
Of course.
And when you first found out about Mr. Musketeer's interest, you wanted Ms. Azoff to know.
Of course.
In fact, she was the first person you told other than your lawyer.
I believe so, yes.
And this was really big information for the company, right?
Yes, but it was also huge personal information.
Sure, but anyone interested in investing in LMNH, whether it be Ms. Azoff or anyone else, they would want to know about a meeting like that with Mr. Musketeer, right?
Yes, any stockholder would like to know if the stock's going to go up.
And you would agree with me that the more stock someone owns before a big deal like that, the more money they would make selling that stock after the price went up, right?
Economics, yes.
But at the time that you told Ms. Azoff about this deal, the public did not know about it, right?
No.
And as you said on direct, on December 14th, you sent Ms. Azoff an email.
Yes.
And in that email you said, and you know I'm about to make it up in a big way.
Yes, but it wasn't pertaining to the Musketeer deal whatsoever.
That's not what I asked you. I just asked you if that's what the email said, Mr. Belford.
Sorry, can you ask the question again then?
Didn't that email say that you sent to Ms. Azoff, and you know I'm about to make it up in a big way? Isn't that true?
Yes.
And you sent that email 2 weeks before the Musketeer deal went public, correct?
A little bit longer than that, but yes.
And at the time of this email, Ms. Azoff had already purchased almost 6,000 more shares of LMNH since you had told her on the 3rd, correct?
I don't know.
You
That's not my knowledge. She didn't tell me she invested. I mean, well, she's in prison now, so that would make sense. But no, at the time I didn't know that.
Okay. But the deal ultimately went through and Ms. Azoff ultimately made a lot of money, right?
Well, I mean, now she hasn't, but yeah, when it first went through, she did.
And she was able to make that money because you shared that information with her before the information was public, right?
There's nothing to say that she wouldn't have invested that without that information.
But you would agree with me that it's unlikely that she would have invested 13,000 more shares in the span of less than 30 days had she not known about that deal, right?
I'm not going to speculate upon her investing.
Okay. But you and Miss Azoff, you'd been friends for a long time before this happened, right?
10 years.
So you knew each other's quirks about each other?
Some.
Strengths and weaknesses of each other?
Some.
And you knew that Miss Azoff enjoyed being wealthy?
Of course.
You knew her as someone who took chances on stocks, right?
Actually, no.
So you don't agree with me that she continually invested in LMNH despite LMNH kind of going on the down for a while?
I agree with you. She continued to invest, but I don't consider it to be a risky investment. I think that investing in me is the best decision you could make.
Because it's your company, right?
Because I'm the best businessman in the world, in my opinion.
Okay. But when you shared this information with Ms. Azoff, you never told her it was confidential information, did you?
I think, do you tell your best friend this? When you tell your best friend a secret, do you say it's confidential?
Would you agree with me that it's important to tell someone that something is confidential if them sharing that information would be illegal?
It could be, yes.
And so you didn't tell her it was confidential, just to clarify, right?
I don't recall telling her it was confidential, no.
And you never told Ms. Azoff not to trade on that information, did you?
I didn't think I had to.
No further questions, Your Honor. Pass the witness.
All right. Any redirect?
Briefly, Your Honor.
You may proceed.
May I proceed? Thank you. Mr. Belfort, did the December 14th email have anything to do with the Musketeer announcement?
Absolutely not.
And did you know at this time that Ms. Azoff was buying more stock in your company?
Absolutely not.
No further questions, Your Honor.
All right. Does the defense have any further witnesses?
The defense rests, Your Honor.
All right. And we are on to closing arguments.
Your Honor, if we may make one more motion outside the presence of the jury.
You may proceed.
We renew our motion pursuant to Rule 29 of judgment of acquittal. The prosecution has still failed to prove their case beyond a reasonable doubt with respect to intent to defraud LMNH and that Mr. Belfort acted deliberately and with a bad purpose when revealing the information.
Response?
Yes, Your Honor. I believe it's been made abundantly clear that the prosecution has met its burden. The court just heard from Mr. Belfort. We know that he told Ms. Azoff this information intentionally. It was not an accidental slip. He shared it willfully with a bad intent. We've proven that he knew that Ms. Azoff would trade on that information. He was familiar with her trading patterns. He was familiar with how she acted in the stock market. And we also have shown that he intended to defraud the company of the confidentiality of that information when he shared it with Ms. Azoff and never told her that it was confidential information and never told her that she should not act on that information. Therefore, Your Honor, we ask again that this motion be denied.
The motion will be denied. The parties may proceed to closing arguments.
Briefly, Your Honor, could we get a time check for the parties before closing argument?
Absolutely.
Yes, prosecution, you have, did I write that down correctly? Let me double check, I'm sorry. You have, yes, 18 minutes and 19 seconds. And Defense, you have, no, I'm sorry. Hold on one second. I'm sorry. Attorneys don't do math, right? Isn't this a thing? Prosecution, you have 9 minutes and 19 seconds. And defense, you have 16 minutes and 9 seconds.
Okay.
Did you want to reserve some of that time for a rebuttal argument?
Yes, Your Honor, I would like to reserve 2 minutes of that for rebuttal.
All right, you may proceed when you are ready, ma'am.
2 best friends and a secret plan and easy money. That's what happened here with Jordan Belfort and Dee Azoff. The defendant's best friend pocketed $180,000 when he sold his shares in the defendant's company that he had just bought weeks before, after the defendant told him about a secret deal that wasn't yet public. And the defendant wants you to believe, ladies and gentlemen, that that was just a coincidence. But we've shown you that it was not. As you've heard in this courtroom today, this is a case about how Jordan Belfort got cocky. You just heard him say he thinks he's the best businessman in the world, how he got comfortable, and how he thought he could get away with helping his best friend cheat the system. But you, ladies and gentlemen, you can do something about that today by finding the defendant, Jordan Belfort, guilty of securities fraud. Now, I'm going to talk about the evidence that we've shown you that supports this, but first I just want to touch briefly on what securities fraud is. First, the defendant must have disclosed material, non-public information to Ms. Azoff in anticipation of receiving a personal benefit in return, and with the expectation that Ms. Azoff would then trade on that information. In doing all of this, the defendant must have acted knowingly, willfully, and with the intent to defraud element H of the confidentiality of that information. And finally, in furtherance of all of this, there had to be some use of interstate commerce involved. Now, on the first, well, actually, let me go through the evidence that we have shown you. First, you heard from Agent Pat Denham, and she told you about her investigation with the SEC into the activities of Jordan Belfort. She told you there was a deal between the defendant and Elon Musketeer, and that deal was a $684 million investment in Element H. You heard that this deal did not go public until December 31st, 2019, but that the defendant told Ms. Azoff about it on December 3rd, 2019. So we know that the defendant shared non-public information with Azoff, and the defendant admitted as much on the stand minutes ago. And you also heard from Michael Powell, an expert in securities fraud, and she told you that that information that the defendant shared with Ms. Azoff was material because any reasonable investor would want to know about a $684 million deal that would save the company. The defendant also just told you that. He said any investor would want to know a deal as big as that. He just told you that minutes ago on the stand. So we know that the defendant shared material, non-public information with Azoff. That is the first 2 parts. As to a benefit, we showed you several. You heard from Agent Denham that the defendant and Ms. Azoff were best friends and close business partners. Agent Denham told you that as of early December 2019, even before Ms. Azoff began trading illegally, she was already heavily invested in Element H. Sharing that info with Ms. Azoff was a way for Mr. Belfort to continue that relationship. And Agent Denham also told you that Ms. Azoff frequently allowed the defendant to use his vacation homes, or her vacation homes, country clubs, even her private jet, excuse me. And Mr. Belfort told you himself on the stand today that those would be benefits that he would lose if he lost Ms. Azoff as a friend. Mr. Belfort did not want to lose those things that Ms. Azoff had. In fact, Mr. Belfort told you on the stand today that he literally asked for a benefit at the same time that he was sharing the information with Ms. Azoff. When he called her on December 3rd, he told her, "Hey, I have this meeting with Mr. Musketeer. Can I use your private jet?" So we know he anticipated a benefit. And we also showed you evidence of the defendant's expectation that Ms. Azoff would trade on this information. First, Agent Denham told you about a December 14th email where the defendant said, "You know, I'm about to make it up in a big way." What did he know? Azoff knew about the deal with Mr. Musketeer before it was public, because Mr. Belfort told her. And how was Mr. Belfort about to make it up in a big way? Belfort was about to finalize the deal with Mr. Musketeer. Now, at the time of this email, Ms. Azoff purchased, had already purchased 13,000 additional stocks. And after the deal, the stock price went through the roof, and she sold those stocks for $180,000 after December 31st. That is making it up in a big way. But what was he making up to her? All of those benefits that we just talked about. A thank you for the trips, the golf, the jet, and a thank you for being a loyal investor that got LMNH through any tough times. But even beyond the email, Mr. Belfort told you that he knew Ms. Azoff was someone that invested regardless of what was happening. That he knew Ms. Azoff was motivated by the money, that she enjoyed money. Mr. Belfort knew that Ms. Azoff would be too tempted and would trade on that information. So we know Belfort would have expected Azoff to do this. And finally, we know that he acted knowingly, willfully, and with the intent to defraud LMNH of the confidentiality of that information. He did not tell Ms. Azoff on accident. He intended to share it with her. That's knowingly. And we know he did this deliberately and with a bad purpose because we know he expected Ms. Azoff to trade on that information. So that's willfully. And we know he shared this information with the intent to defraud LMNH because he shared it with her, never told her it was confidential, and never told her not to act on it. That's intent not to keep it confidential. And finally, the scheme had to have utilized interstate commerce. We heard from Agent Denham that when Ms. Azoff did illegally trade on these, it was on the Lone Star stock market. And that's an aspect of interstate commerce. So the final element is also met. So as you can see, we've provided you with evidence of every single element that we have to prove to you today. And we have to prove these to you beyond a reasonable doubt. That just means that with each of these elements that we just talked about, a reasonable person, a reasonable juror, wouldn't hesitate to rely upon that information in finding the defendant guilty. It is not beyond all possible doubt. Everything in life is open to some possible doubt. What we have to get you to, and what we did get you to, is beyond a reasonable doubt, a doubt that would cause you to genuinely hesitate before finding him guilty. But we are confident, ladies and gentlemen, that we have presented you with the evidence that proves each and every element beyond any of those potential reasonable doubts. So when you go back to that deliberation room, you're going to get a jury verdict. And that jury verdict is going to have two blanks. One that your foreperson will sign if you all agree that the defendant is not guilty, and one that they will sign if you all agree that the defendant is guilty. Remembering all of the evidence that we have presented you with here today, and remembering how all of that evidence has been shown beyond a reasonable doubt, we know that you will come to the only conclusion that the evidence supports and that justice demands, and that is finding the defendant, Jordan Belfort, guilty of securities fraud. Thank you.
You may begin when you're ready, Mr. Hargis.
Thank you, Your Honor, and may it please the court. Ladies and gentlemen of the jury, at this point, you have heard the testimony and little evidence that the prosecution has against our client, Mr. Jordan Belfort. You've also heard the case put on by Ms. Borthwick and me in defense of Mr. Belfort. Now, the prosecution had the burden of proving a very high burden, guilt beyond all reasonable doubt, the highest burden recognized by law, with respect to each element of the case. Now let's talk about the first element the prosecution was required to prove. The government must prove beyond a reasonable doubt that Jordan Belfort disclosed to D. Azoff the information specified and that it was material non-public information, that Jordan Belfort anticipated that D. Azoff or others would trade on that information, and that Jordan Belfort, in return for providing this information, anticipated receiving some personal benefit. If you recall his testimony, Mr. Belfort intended for Ms. Azoff to keep this information confidential, not go out and trade on it. Mr. Belfort had every reason to believe his friend, Ms. Azoff, would keep this information confidential because she always had. Does it sound like Mr. Belfort expected to gain something from sharing information he wanted kept confidential? That's reasonable doubt, ladies and gentlemen. For the second element, the government was required to prove beyond all reasonable doubt that Mr. Belfort acted knowingly, willfully, and with an intent to defraud his company, LMNH, when he disclosed this information. Now let's talk about the second of those, willfully, meaning deliberately and with a bad purpose. You heard testimony that LMNH was struggling a bit financially. When Mr. Belfort learned of the potential investment of $684 million, he was ecstatic. So what did he do? He told his best friend of 10 years about this exciting news. Now imagine if you, after enduring years of a struggling business, received news like this. Wouldn't you be dying to tell your best friend about it? Simply because it was your best friend. There was no bad purpose here. Then there's the intent to defraud requirement. Now, the prosecution would have you believe that Mr. Belfort intended to defraud LMNH, the company he built and loves, of the confidentiality of its information. Now, to facilitate this, the prosecution put on two witnesses, one who brought this case to them in the first place, and another they hired to reach a conclusion that fit their narrative. Now, Agent Denham talked a lot about jets and country clubs and fancy dinners, but did Agent Denham ever offer any evidence that Mr. Belfort intended to defraud his company? No. Could the expert witness offer any evidence that Mr. Belfort intended to defraud his company or stood to benefit from Mr. Azoff's trades? No. That's reasonable doubt, ladies and gentlemen. Now, you heard yourselves what kind of person our client, Mr. Belfort, is. The prosecution would have you believe him to be this rich, stuck-up socialite who has simply coasted his way through life. But in fact, my client has worked every day for his money and for the success that his company has become. You even heard testimony that the main reason Mr. Belfort was pushing this investment was to benefit his shareholders. Now, lastly, ladies and gentlemen, I remind you of the misappropriation theory. If the tipee, being Ms. Azoff, misuses or misappropriates information to trade in securities, she breaches the duty of confidentiality she owes to the tipper, Mr. Belfort, and can be liable for insider trading. But even though the tippee, Ms. Azoff, is liable, the tipper, Mr. Belfort, may not be. For example, if he did not act knowingly or recklessly or receive a personal benefit. Now, Ms. Azoff, the tippee, committed insider trading. She pled guilty to it. She breached her duty of confidentiality owed to Mr. Belfort. We know that. But we also know that the prosecution failed to meet its very high burden of proof beyond all reasonable doubt. Ms. Azoff's greediness and betrayal of her best friend's trust are the only wrongs that were done here. Ladies and gentlemen, considering all you have just heard, I submit to you this case is tainted with reasonable doubt with respect to multiple elements of the crime charged. I further submit to you that the only plausible conclusion for you to reach is to find our client, Mr. Belfort, not guilty. Every notion of fairness and justice commands you to do so. Thank you.
Thank you, Mr. Hargis. Rebuttal, please.
May it please the court. The defense just got up here and seemed very bent on the fact that there's no evidence that this crime or that Mr. Belfort acted willingly in this case. But what they failed to tell you is that's tied into the expectation element. And we have brought you evidence of that expectation that Mr. Belfort had on multiple occasions today. Additionally, we know that Mr. Belfort acted recklessly, that misappropriation theory that the defense was just telling you about. He said that doesn't apply if the defendant acts recklessly. We know that the defendant acted recklessly in this case when he told D. Azoff in the first place, knowing that the evidence was, or that the information was material and non-public. He told you on the stand today that he knew when he told her that it was material, non-public information. Now, the only evidence that the defense has that Mr. Belfort had no expectation of that D. Azoff would trade on this information comes from Mr. Belfort himself, the best businessman in the world, and from Ms. Azoff. And you heard Ms. Azoff get up on the stand today and lie about whether or not she told her stockbroker about the information that Mr. Belfort gave her. You heard on cross-examination, you heard her lie about that. We saw the testimony. And now if she was willing to lie about that, what else is she lying about? Ms. Azoff fell on her sword in this case. She's the one that traded and she's the one that's pled guilty. She took the fall for what she did, but we can see that she's also covering up what Mr. Belfort knew about that. So ladies and gentlemen, we have shown you the expectation element and we have shown you the willful element. They're intertwined. Thus, ladies and gentlemen, when you go back to that deliberation room, we ask that you find the defendant guilty. Thank you.
Thank you.
Okay, great job, guys. If the judges will go ahead and finish up their ballots and send those in, I will quickly put those into my own little calculation spreadsheet, and we will announce a winner here in no time.
Great job, guys.
Y'all too.
Good job, everyone.
I honestly want to know like how this case would actually go in real life.
I personally think it's a defense favor case, not prosecution.
I think so too.
Definitely go in 55 minutes per side.
Yeah.
Yeah, that would have probably, I've worked on a few securities fraud cases and they can be months.
Mm-hmm.
So.
Yeah, when Amanda, when you told me I had 9 minutes to do a closing and a rebuttal, I was like, okay, I'm just going to talk really fast.
Yeah, well, I mean, you had some tough witnesses on cross, so you had to take a little extra time on those tough witnesses, but that's what makes it interesting, right?
Exactly.
I think this was a battle of the witnesses for sure. They were all good.
Yeah, witnesses are super crucial. Super
Yes.
crucial.
And you all did. You all had great witnesses. It definitely helps or hurts, depending on which side you're on, I guess.
Okay, we're just waiting on one more judge's ballot. And once we get that, if the judges will go ahead and give some critiques while I'm inputting the numbers. And then hopefully by the end of that, I will have the results. I think we're just waiting on one ballot.
So are we allowed to talk here?
Yes, absolutely. Please go for it. Please go for it.
Mark, how are you doing?
I'm good. How are you, Spencer?
Good. Haven't seen you in a while, but happy to have you as a judge.
It's good seeing everyone, and it's good seeing folks still participating in mock trial, even though I know finals are probably coming up, and I don't know, you guys are probably trying to cut this in along with your studies. So hats off to everyone for liking mock trial enough and trial advocacy to put the time in that you did this weekend and the past couple of days. I don't know. I just like seeing folks who are still interested in this sort of advocacy part of lawyering.
Okay, y'all, we just get the last ballot. So let's go ahead with critiques. If each of the judges wouldn't mind introducing yourself before going into it.
Saoirse, you want to go first?
Sure. My name is Sarah Beth Landau. I am a judge on the First Court of Appeals here in Houston. But before that, I actually was a federal public defender where just coincidentally, I actually defended these kinds of cases. And I actually worked on the biggest fraud pre-Enron, which for some reason took 10 years to investigate. So this was actually kind of fun for me to listen to this very, very creative application of a mens rea to somebody else who didn't actually do the trading. But I thought you all did such a wonderful job under these difficult circumstances. I would have been completely terrified to draw a graph in the middle of a Zoom trial, and everything was so smooth. All of you did such a nice job. I could understand everything you were saying. I thought that your questions were very clear. Your objections were very clear. I was just very, very impressed with all of you. And I thought that the handling of the evidence went so much smoother than I thought it would have over Zoom. Because I'm an appellate judge, not a trial judge, I haven't had a Zoom trial, and this is the closest thing I've had since the pandemic. And I was really impressed with all of you. Let me see here. I took some notes. Let's see here. Now, with that sort of general, everybody did pretty awesome as a backdrop, I did have a couple of suggestions. If you want to move for a mistrial based on something where someone has misstated the burden of proof, you have to kind of do it in the right order. So first you have to object, and then the objection needs to be granted, and then you ask for an instruction, and then the instruction is given, and then you move for a mistrial. I would not start at the mistrial as your first move. So that's just a technical thing. And probably the burden of proof was misstated. So that was a valid point to bring up. Let's see here. I thought you all did really well on your objections pretty uniformly. I thought all of you had kind of a good mix of very solid objections and a few reaches, which I think is what you want. You don't want to always go for the one that 100% should be granted. You should probably be objecting a little more than that. But you don't want to have a bunch of frivolous objections, because then the judge is not going to listen when you speak. So I thought you guys kind of hit the right balance with those. Let's see. If someone else wants to hop in, I might want to take a look at my notes before I have more comments, and I don't want to make you sit through me looking through my notes. So if someone else has other comments, I may jump back in later.
Mark, you want to go?
Sure. Great job, everyone. Like I was saying, one, I'm just really happy and proud to see folks doing mock trial this close to finals and on a Sunday afternoon intramural tournament. That's just always a good thing to see. Few things, and mostly going to stick with, I like to talk about sort of Zoom type things because this is new to all of us and I'm still learning. And as I watch more and more trials on Zoom, the more and more I learn about the types of things that you'll experience as a trial attorney with juries if you ever do a Zoom trial, if we're still doing them, hopefully not. But distractions are a big thing. And I've talked about this, with the folks who've seen me in mock trial coaching, and distractions kind of range abroad. Like there's a broad range of things that can be considered a distraction, from stuff that's in your background, like a shark poster, Packard, or everyone else. Very good job in having a very sort of sort of clear background behind you, whether it's a white wall or a door. But jurors will get distracted and they'll get bored, and they'll look at the things behind you. They'll look at the poster, they'll look at your mattress, they'll look at the furniture that's in your in your room. So you want them and their focus to be on what you're saying, on what you're present, on your presentation, on what your side of the case is. So don't give them an excuse to look at, even the neat knickknacks in your room. I have a neat knickknack. I have like a rhino that I bought from Ross that is not hung up on the wall yet, but will be hung up. And it's like, I would not have that in the background during a mock trial or a real trial, because everyone would be like, look at the neat rhino. I think my wife is going to go get the rhino. Other than that, glare. This may be difficult for folks who have glasses, but my one piece of advice is to make sure that your little video webcam is always clean, that your glasses are always clean, and that the lighting around you, because this was happening in a few web windows that I was seeing, whether the lighting in the background looks, whether it's causing glare, because we have now changed from stage actors, so to speak, as advocates to now screen actors. So we need to be paying attention and mindful whenever we're advocating about everything that's going on here. And that kind of leads to my second point. When we're making a point, you got to make the point or the gesture within the screen. Some of you guys were doing a pretty good job of making sure that your hand gestures were here. This is where all the action is happening. So if you want to make a point, you want to say something, you want to count something out, make it here. Leads to my final point, eye contact. Normally when we're making eye contact, we would look at someone's eyes. And in this case, we look at the webcam directly. And some of you folks did an excellent job of keeping that in mind, that in order to make eye contact with the trier of fact, whoever that is, whether it's a judge or jury, look at the webcam. But that being said, it's also extremely obvious when you're reading something. And I know that this is probably, like I said, close to finals and you guys got a lot of things going on, but I could tell when you were reading, whether you're witness or attorney off of your screen. Like your face is so close, you can see the eyes go back and forth, right? So next time, try to curb that out. It's just makes the presentation 1,000 times better. But other than those sort of Zoom suggestions, I'm gonna hand it back to either judge to pick up. And good job, everybody. Very, very impressive round. Very cool problem. Cool to see you guys do it.
Saoirse, did you want to? I'm sorry, Justice Landau, did you have anything? Sorry.
My notes were super helpful. I was like, good cross, and I can't tell what witness that was for. So one of you did a particularly good cross. No, I do not have specific.
Well, I'm Christine Weems. I'm judge of the 281st. I'm a sitting judge here in Harris County. I'm a civil sitting judge. So I'm glad that somebody with criminal experience was presiding over this case, because I always forget about things like you got to ID the defendant and you got to, establish venue, because you just don't do that in civil cases. I'm also the director of the mock trial program here at University of Houston. So, I definitely have to say I'm absolutely impressed by all four of you. And I'm not gonna lie, your witnesses all uniformly cracked me up. Like all of them were excellent. And I often think that, being a witness in a mock trial tournament is kind of a thankless job. And like, they just kind of show up and they just have to say facts. And I was so engaged by y'all's witnesses. They were fantastic. The way they pushed back on cross, I was like, oh, dang, they are invested. And so your witness, I just want you to know, I don't know, I think some of them have left the call, but your witnesses did both sides credit in terms of pushing your cases. And even though there's not a place to score witnesses, it did make an impact on scores in terms of obviously directs and crosses because of their participation and how they participated. So to that extent, good job. Mark covered a lot of the things that I was going to say, because unfortunately, I think Zoom is going to be with us longer than it's like for the near future. I actually have a jury trial coming in actually on Monday. I'm starting a jury trial on Monday, and it's going to be fascinating because there's all these, it's going to be live and the lawyers are going to be live, but for purposes of what y'all are doing, I do all my bench trials over Zoom, and I know that all of the mock trial tournaments in the near future are going to be all over Zoom. So you kind of have to get used to this world. So, everything that Mark said was spot on. The other thing that I would add to it, though, is in terms of kind of what he was talking about with distractions, a very, very real thing that I guess and again, we are also all learning how to navigate this medium, because it's like, I can coach and teach advocacy, but it's usually when you're walking around in a courtroom. So this whole notion of like confining yourself to a little square, very different. We're all learning. And one of the things that we are learning and we are seeing is that you have to be very mindful if you are on screen and not talking. And what I mean by that is, in any other world, if I am on the bench and somebody's doing direct over here, I'm looking over here, and the witness is over here, so I'm looking over here, and I'm not looking at the person doing cross over here. But on Zoom, y'all are all right in front of me. So I can't help but look at you. So even if you don't think people are paying attention to you because you're not saying anything, or you're like just listening while a cross goes by or while direct goes by and you're just getting ready for your cross, we are watching you and it can't be helped. And I'm not trying to pick on you, but like, Miss Borthwick, I don't know if you know this, but you make interesting faces. You're like chewing on your lip, you were kind of looking down, and it's just, I don't think you realize it because it was while the direct was happening that you may not have realized that because you're all right in front of me, I couldn't help but look at you. Whereas if we were in a courtroom, I probably wouldn't be looking at you. I would probably be looking at where the action was. Well, unfortunately, right now, all the action is in front of me all of the time. And it's like the same thing, Mr. Packard. Every time your head moved to the side, I was like, hemorrhage shark, nice. You know, these are things that can't be helped because of the nature of this environment. You are always in front of us. So you always have to be mindful of how you hold yourself, what you're doing, because I can't escape you. When your camera's on, I literally can't escape you. So I'm seeing it all the time. Generally, I mean, I have some specific notes, obviously, that I can't read because I write too fast while rounds are going on. The thing I will say is this, is that I feel like on directs, particularly for this kind of case, that y'all did not get as much joy out of it. And I think most people think that kind of directs are kind of boring. You just have to get the information out and stuff like that. But directs matter. How you sell the information to the jury matters. I want to stay engaged and invested. And if your direct is, I ask a question, I get an answer. I ask a question, I get an answer. Then I just start looking around at things in my world, or, you know, start noticing things like what's in your background and that kind of thing. And so I tell you that you shouldn't shortcut directs. You should find a way to infuse it with energy and infuse it with your personality. I think a lot of young lawyers or young people early in their careers, or while you're in law school, you don't put enough of your personality into these things, and you should. You should, because you want a jury to like you, and that will help sell your case. Obviously, you don't want to do the reverse, which is if a jury has any reason to hate you, then you don't want them taken out on your client. But I'm not saying be casual, because it is a very formal, very serious proceeding, but think about ways to make your directs more engaging, more conversational. Listen more. So when they say something, pick up on it. So it sounds like, because in the real world, in a real direct, and I practiced law 18 years before I took the bench. The reality of it is that I never went through question by question a direct with any one of my witnesses before I took them into trial. I tell them, these are generally the kinds of things we're going to talk about. These are a couple of the big ticket issues I need to make sure that you say. But generally, we never went through, this is everything I'm going to ask, and this is everything I need you to answer. Because I know what story I want out of them. So I'm going to get it by asking the questions I need and by listening to how they respond to take me to the next point. So that's kind of my advice, is that relax, loosen up, have some fun with it. Directs can be fun too when you make it engaging and infuse some of your personality into it. So those are my general comments. If Justice Landau, I'm sorry, I shouldn't be calling you social. If Justice Landau or Mark, you have anything further, please jump in. But those are kind of some of my general comments.
Just here's the rhino I was talking about. It's supposed to hang up on the wall like that. This is the type of thing you don't want in your background.
Very distracting. Absolutely.
Very distracting. Other than that, I want to echo Judge Weems with you all had excellent witnesses. And I don't know whether that's because you prepped them or whether they were just, automatically, inherently charismatic. Particularly the defendant, Jordan Belfort, came into this thinking that I was going to have, a Wolf of Wall Street, DiCaprio, guy, and he was likable. And when you have a case that's a criminal case and your defendant is likable, and I'm here sitting listening to his direct and his cross thinking, I don't want to put this guy in jail. Y'all are doing a good job, or he is doing a good job. And if it's him doing a good job, don't let that gift go away from you. To Judge Weems's point about having fun on direct or making it a good, engaging direct, because I didn't want to put Jordan Belfort in jail.
I thought he was very effective. And just sort of a counterpoint to what Judge Weems said, federal prosecutors do not have usually joy in direct. So if you can get there, good for you, but that's not usually their MO. It's very, here are the elements, I'm applying them with the facts we have in front of us. It is your solemn duty to find this person guilty. That is kind of their vibe when they are doing their work. You get a little more joy from the defense, particularly if they have a great witness who they get to put on the stand as their client. But yeah, it's hard to find joy as a prosecutor because it is a solemn duty. This is someone who could be going to prison for 20 plus years. You certainly want to be careful with the tone that you strike. That's not to say you can't infuse your personality, but you have to be, I think it's hard to do that well. That's a tough skill.
All right, everybody. Thank y'all so much for the feedback. The numbers have been crunched. But before I have Amanda announce the winner, I just kind of want to say real quick, after the winner is announced and the best speaker is announced, I would like to take some screenshots. So if after everyone's, finishes, woohoo, the confetti kind of clears out, if everyone could still stay for a second, because I have a list of pictures that I would like to grab. Okie dokie. So enough of me. I'm going to toss to Amanda, our lovely competition director.
All right, so ladies and gentlemen, after a very tough fought battle, we came down within just a few points as we thought that it would. And we are excited to announce that Mr. Packard and Miss Bentley have won Hippard Open 2020. So congratulations to the two of you on a well-deserved victory. Yay. And additionally, for our best speaker, that goes to Miss Brooke Bentley as well. So great job to everyone. Thank you for making this such a successful tournament. It was really great. I'm so glad that I got to watch the finals from this side this year. It's way less stressful than being on that side. So great job, everyone.
Thank you all so much.
Yeah, that was a blast.
Yep. Thank you all.
Super fun.
Thank you, guys.
Team one, y'all did awesome. Y'all really killed it. That was
Thank
great.
y'all. Y'all too.
Yeah, we learned a lot from y'all.
Absolutely.
I mean, team one for not being members of mock trial and having, all of that experience, you really did a wonderful job. And I'm sure that people are going to be trying to snag you up for mock trial. So, it could happen. We hope to see you in the future for sure.
Yeah, it's absolutely true. Brooke and Spencer, I know y'all personally and have seen y'all, so I knew that you guys were fantastic. For team one, Brett and Casey, I don't know y'all, but seeing the scores round after round after round after round, which I say that a lot because I'm sure that's what it felt like. You guys did fantastic. I don't know if you guys noticed that these two teams didn't go against each other in the semifinals, and that's because you guys really were the two teams that kind of were strongest. So, throughout. So you guys should all feel really, really proud of yourselves. This was a difficult problem. This was not your typical, sorority problem or, murder problem, anything like that. This was something difficult. This was something with a lot of statutes and a lot of really different looking materials in the packet. So really congratulations to everybody. Okay, so before everyone runs off, I want to get a few pictures. First, I want to get a picture with everybody who's on the screen right now. Okay, so if everyone could just look at the camera, give a nice smile all at once, keep your eyes open. Okay, I don't think anyone blinked. By the way, I did get a picture of the rhino, so that also is now in the archives. And everyone's also smiling in that with their eyes open, so who knows, maybe I'll just use that as the winning picture instead. Okay, now if we could get one with the winners and with the judges.
How do we do that?
Oh, okay. So on my screen, I have it to where it's hiding all non-video participants.
Oh, gotcha.
So if you just turn your screen off, then that'll do the job. Okay. Okay. 1, 2, 3. Yeah, and Judge Weems taught me that non-video participants trick, so that credit goes to her. Okay, if we could get a picture with all with our runner-up team and with the judges. Okay, lovely. All right, everybody smile. Okay. Lovely, perfect. Okay, now if we could get just the competitors, our finalists. Okay, there we go. Okay. Oh, this is nice. This is 4 people, so it's a nice big screen. Okay. All right, lovely. Okay, and then one with the competitors and Amanda.
Well, what about you, Chelsea?
No, I don't wanna.
And what about you, Chelsea? What about you too?
Get in on this.
I'm not the competition director.
Yeah, but you're like the bad bee of the competition that handles everything. So
Okay, well let's
Chelsea, turn your camera on.
I'll hop on, but it's not okay. That's fine. Okay, here I
I
go.
couldn't have done it without you, so you get credit.
Okay. Hi. Okay, I'll scoot back. All right, everyone smile. Okay, lovely. And I think that those are all of the pictures that we needed. So if everyone wouldn't mind just hopping on again for just a second so that we can all, let's see here. Okay, lovely. All right. Well, to our competitors, thank you so much for your hard work and congratulations. To our judges, thank you so much for volunteering your time, volunteering your expertise, for giving feedback, for hopping onto the strange forum, and for being thoughtful and creative with your critiques. We really appreciate it. And also, I really appreciate y'all very swiftly sending in those ballots. Very, very appreciated as the number cruncher. And thank you so much to our beautiful, talented, awesome competition director, Amanda, who killed it and gave us all this great experience and this opportunity to get practice. And so great job, everybody. And that's a wrap for the Advocates competitions this semester. Wow. All right. Well, y'all go and have yourselves a lovely evening.
Do some celebrating.
Thanks again.
Thank you all.
Thank you all so much.
Thanks, everybody.
Have a great weekend.
You too.